It's easy to misjudge this case 75 years after the relevant events, but in the 1950s, communism was expanding by fire and blade, and there was a real sense that Australia needed to protect itself against that evil ideology. The Menzies government passed the Communist Party Dissolution Act 1950, which dissolved the Australian Communist Party, confiscated its assets, and gave the Governor-General power to declare associated organisations to be forbidden. This was intended to prevent the Communist Party from just reforming under another name. One difficulty was that regulating voluntary associations was a state matter. The Commonwealth relied on the defence power and on the general executive power under Section 61 of the Constitution, which says the executive power of the Commonwealth extends to the execution and maintenance of this Constitution and of the laws of the Commonwealth. So anything which threatened the very existence of the Commonwealth could empower the Commonwealth to counter that threat. The High Court found the legislation invalid. The justices differed about how far the defence power and Section 61 could be stretched, short of an actual war and against Australians. The real obstacle, however, was the power given to the Governor-General, on the advice of the relevant minister, to simply declare organisations forbidden if the Governor-General was satisfied that the organisation was communist and a threat to Australia. Justice Fullagar said the validity of an administrative act done under a law cannot be made to depend on the opinion of the person who is to do the act, that the consequence of the act is within the constitutional power upon which the law in question itself depends for its validity. A power to make laws with respect to lighthouses does not authorise the making of a law with respect to anything which is, in the opinion of the lawmaker, a lighthouse. A power to make a proclamation carrying legal consequences with respect to a lighthouse is one thing. A power to make a similar proclamation with respect to anything which, in the opinion of the Governor-General, is a lighthouse, is another thing. This case confirmed that while the defence power sometimes enables governments to take extraordinary steps, Australia is a nation of laws binding even the Parliament, which may only make laws within its heads of power, and which may not remove the adjudicative jurisdiction of the courts.